Hello and welcome. This is module 33 and I am Professor Rashmi Raman. In this module, we will continue the case study of Cambodia that we started in module 32. But this module is called part 2, a study of criminal justice and politics. Now, what is the point behind asking you to do a case study on criminal justice and politics? Let me explain this to you through an illustration. What do you see? Some of you looking at this image will tell me that you see a duck. If you imagine that these things are the beak, then this is a duck. But if you look at these as ears, then this is a rabbit. This is Wittgenstein's duck rabbit, and this is a very important tool in studying the idea of dualism. Depending on who you are, you will see in this image either a rabbit or a duck. But it is impossible for you to see at the same moment in time both images simultaneously. You might be able to see them separately, but you will have to reorient and refocus your mind to understanding which part of it is the duck and which part of it is the rabbit. This idea of dualism was propounded by German scholar and philosopher Wittgenstein, and I am using this as an illustration to show you law and politics, and to show you that the dualism of the duck-rabbit metaphor mimics the idea that two sides of the same principle or the same concept can have two different repercussions depending on perspective. For Cambodia, it is the same. If you are interested in studying the politics of the Hun Sen government, how the Hun Sen government inherited from Norodom Ranariddh, how they overthrew Norodom Sihanouk and got over his political objections, and how the Cambodian royal family decided its own political destiny by sealing a deal with the United Nations that would let them be exempt from the criminal trial proceedings before the new tribunal, you are looking in this case at the politics of Cambodia. In addition to the politics of prosecution, an important aspect of the politics of Cambodia are the politics of aid, the politics of poverty, and the economies of scale. The Cambodian genocide left the entire country almost entirely bankrupt, and the Cambodian genocide case becomes a case study in rebuilding an economy from bottom up. However, if you are looking at the other aspect of this picture, depending on who you are, if you see this as a duck, then you are looking at the legal aspects of Cambodia. And the legal aspects of Cambodia are frankly quite worrying. That an international criminal tribunal was set up 30 or 35 years after the end of the genocide. Secondly, that the international tribunal represented in its very origin a compromise between the national and the international. Thirdly, that it was prosecuting people who were already in their 80s and 90s at the time that they stood to trial, having lost their memories, most of them their health, and very vague recollections of what was their role in the Cambodian genocide. And finally, that the evidence presented by prosecution was not forensically sound because it was over 40 years old. If you look at the criminal justice part of it, the legal part of it, the duck part of it, these aspects will present to you a frightening picture. And one might say that it is easier not to prosecute at all in Cambodia than to go ahead with prosecutions that appear to be at best some kind of a sham. But the truth of international justice and politics is in taking not a partisan view of either politics or of law, but try and striking a balance, an arbitrable balance between the two, which allows you to kind of unite the two in an exercise that we have understood in the past as transitional justice. If one looks at the Cambodian state as a state in transition, then and only then this case study makes sense, because the Cambodian state in transition represents a story for the Cambodian people, a story from which they want closure, a story of dealing with their own history and reckoning with their past in order to create a path to move on to the future. And that is precisely what I will strive to do in this portion of our study material. Welcome to module 33 and part 2 of International Criminal Justice and Politics, a case study of the extraordinary chambers in the courts of Cambodia. We will now begin the second part of our study of the extraordinary chambers in the courts of Cambodia. In part 1 of this module, you have observed an introduction to Lon Nol's Cambodia, the creation of democratic Kampuchea, the destruction of democratic Kampuchea, and the New Deal. Though the United Nations and the Cambodian government agreed in principle on limited prosecutions, they found it difficult in fact to agree on the precise number of persons to be prosecuted by the court. The Cambodian government in 1999 opined that only 4 or 5 senior democratic Kampuchea leaders ought to be tried. The United Nations group of experts advocated for the prosecution of these 4 or 5 along with those others most responsible for the most serious violations of human rights law and the rule of law during the rule of the Cambodian party, and estimated that the trials could run up to 20 or 30 persons. The United Nations group of experts was of the opinion that the court should prosecute not only senior leaders with responsibility over the abuses, but also those at lower levels who were directly implicated in the most serious atrocities. These differing views on the scope of the prospective tribunal's personal jurisdiction created the beginning of a potential zone of conflict between officials of the United Nations on the one hand and the Royal Government of Cambodia, the RGC, on the other. The United Nations, as is its wont, emphasized the importance of fair trials while establishing the ICTY, ICTR, ICC and mixed courts, aware that their legitimacy and credibility depended on perceptions that they were all treated and that they treated all sides fairly. The statutes for each tribunal include provisions that incorporate ICCPR rights. Some critics have accused United Nations sponsored tribunals of pandering too much to the demands of the defense to the detriment of expeditious trials, something that is extraordinarily difficult thinking of the age of the defendants. The definition of crimes as adopted by the internal rules of the ECCC show the difference between the international and the domestic actors that come together in drafting these rules. The internationally accepted Rome Statute definition of genocide, crimes against humanity and war crimes, etc., that are clearly enunciated in the ICC's elements of crimes and exist in similar form in relevant international conventions on the topic, are accepted more or less universally, not only as definitions arising from universal treaties, but also those that comport with the principles of customary international law. The limitation of international law as it now exists should not be used as an excuse to shackle the judges from trying to do full justice to the horrors of the torture chambers and the genocidal outfit that defined the Red Khmers. To give you an example and to speak in some detail about it, let's discuss the Tuol Sleng Torture Center. The Tuol Sleng torture evidence and the risk of misuse by torture evidence for terrorism. In assaying grounds where the ECCC may leave an indelible mark in the conduct of its ongoing trials, a second aspect, aside from genocide, that is of vital significance is the area of torture. There is nothing explicit in the rules of the ECCC that ingrain the exclusionary rule of Article 15 of the Torture Convention. But Cambodia is a party to the Torture Convention, and while the hybrid tribunal as an institution separate from the Cambodian state is not in itself bound by the treaties to which Cambodia is a party, it is bound by the agreement between Cambodia and the United Nations. While it is also true that the importance of the Tuol Sleng evidence cannot be ignored, and that it is important to understand that Tuol Sleng plays a vital role in bringing the trials to a successful end, it contains detailed documentation of the torture center known as S21 that Doik failed to destroy when they emptied it out in a hurry in the face of the Vietnamese incursion of 1979. Tuol Sleng or S21 therefore is a veritable treasure trove of individual detailed biographies of each prisoner interrogated and eventually tortured and executed at S21. It thus cinches a snug case for issues such as command responsibility and joint criminal enterprise that the prosecution of the ECCC have been battling relentlessly to push forward since the inception of the arrests of the 5 indictees. It is quite apparent now from the international political trend that in a short while from now, inmates and detainees of infamous detention centers such as Guantanamo Bay will also very likely face trial. If at that time a precedent from the extraordinary chambers in the courts of Cambodia is made available, which will carry a great deal of value due to the impressive mandate of the ECCC, it is very highly probable that that precedent will be cited to admit the evidence of torture before military tribunals in cases of terrorism, generating an avalanche in which I see potential to destroy a great deal of what the Convention Against Torture worked so hard to protect in the first place. Secondly, using the silver platter doctrine, that even allowing for the tribunal to carve out exceptions to the exclusionary rule in the hope that justice will be done better, will not necessarily achieve the mandate of the court. The silver platter doctrine recognizes that the exclusion of torture evidence will not have a deterrent effect when the prosecuting authorities themselves were in no way involved in the acts of torture. Conversely, it recognizes that when there is involvement of the prosecuting authorities, admission of the evidence would render the court an accomplice in the torture and would therefore defile the judicial process. These two modules taken together bring for you a variety of issues that have plagued the extraordinary chambers in the courts of Cambodia since the time of their creation. We bring this information to you in a way that highlights the present crisis of legitimacy that the tribunal is facing. A financial crisis coupled with corruption charges and allegations of kickbacks during recruitment of national side staff, while maintaining that the establishment of the tribunal itself was a moment for the triumph of justice over impunity, and that the goal it has set out to itself to achieve must be fulfilled. But there is a clear warning that the desire to get judicially creative might have disastrous long-term repercussions for international criminal law as a discipline. An overwhelming reason behind this lies in the compromise that was highlighted earlier in this module, that the international side is almost entirely powerless in the hands of the royal government of Cambodia, and that the RGC seems to have taken a rather convenient view of what constitutes justice, leading me to think that in reality the only value the tribunal and its trials really carry is that of symbolic justice, a puppet trial of aging defendants in a court constantly resource strapped to proceed with the trial, sluggishly moving along with the murky flow of the Tonle Sap River in Phnom Penh, both mute witnesses to the horrors of the past, a token trial in the name of justice in the present, and a grim determination to move ahead bravely, with or without a sense of closure about the past, armed with nothing more than hope, nothing more than the resilience of a people that have suffered worse than death, but ask nothing from the world. Let us now place in this context the recent controversy about the sanctity of this tribunal as a court of law based on the allegations of corruption. It has become increasingly apparent that any steps that this court will take in its course of existence will count a great deal towards the progressive development of law in the area of international criminal trials. The trials have generated a significant amount of speculation over the last 6 years, ever since the persistent doubts and questions about the transparency not only of the proceedings but also of the corruption allegations came to be widely reported. It now looks as if the corruption which has become a major problem at the heart of the tribunal, even though it is as yet unproven but under investigation, at both the administrative and judicial levels, corruption comes as the most crippling, stumbling block in this short but widely publicized and colorful history of the Khmer Rouge trials. Just when, on the one hand, the funds allocated to the national side of the trial are fast depleting, and funding for the international side has become a real problem. But on the other hand, the first trial has completed, and the whole world watched in joy as the tribunal ended what has come to be understood as a culture of impunity in the country. Let us end this study of modules 32 and 33 by reflecting a little bit more on the Cambodian genocide. As I have explained to you in the past, the Cambodian genocide is extraordinarily important to us as Indian scholars and lawyers and students of law, because out of the genocides that we study, this is the only one that took place in Asia that we are studying. This is not to say that there have not been other incidents of ethnic cleansing or genocidal attempts in other states in Asia, but mainly to underline that this is the one that we have chosen to study. As an Asian state ourselves, there is a certain amount of reflection that can be gained by studying the Cambodian genocide as an exercise in the development of the Asian psyche or the Asian way to respond to a crisis. The Cambodian people have shown a remarkable amount of resilience in coming out of the genocide. If you visit Cambodia, you will find that everybody is fairly young, and that the older generation of parents and grandparents has been completely annihilated by the genocide. There is nobody from that generation alive today. Cambodians have also become more urban than rural after the genocide. All of these changes, coupled with changes in the law, the governance mechanism, and this small but incremental steps towards liberalism that are being taken by the Cambodian government, it is hoped that they will steer the Cambodian people towards a brighter future. Thank you.